Created before the advent of Christianity, the Hippocratic Oath has stood the test of time as one of the oldest binding documents in recorded history. Written in antiquity, its principles are summated by the Latin phrase primum non nocere, translated as first do no harm. In a world of rapid technological advancement, innovations in medical treatment and life support are used every day to treat patients nearing the ends of their lives.
Either they go or I go. The issue's got to be raised to the level where it is finally decided.
On the cusps of death, some terminally ill patients seek an alternative solution to end their pain and suffering. The term euthanasia originates from Greek, meaning good death, and refers to the practice of intentionally ending the life of another in order to relieve pain and suffering. Although banned by the Hippocratic Oath of the 5th century BCE, euthanasia was still practiced by physicians as a means to relieve patient suffering and provide a humane death. The ascendancy of Christianity and developing field of medicine reinforced the views of the Hippocratic school of thought, forbidding euthanasia and assisted suicide through the 19th century.
You have many people who have either religious beliefs or just moral convictions that we're not actually in charge of deciding when it's our time, that that's really in God's hand, and that we as humans don't actually have the authority and power to make those decisions. It's not really these aren't really our lives. They belong to God, and therefore all life, however it is being lived, whatever the state, whatever the quality of life, it's really not up to us to judge. So if you're from that standpoint, then the feeling is this is always morally wrong, because it's really not our choice to be able to do that.
On October 1st, 1976, California Governor Edmund G. Brown Jr. signed the California Natural Death Act into law, making California the first state to authorize terminally ill patients the right to refuse life-sustaining medical procedures. This act was key in giving patients more control over their medical care and an important step forward. By 1977, 7 states had adopted similar laws, and by the turn of the century, all U.S. states had enacted natural death laws. Derek Humphrey then founded the Hemlock Society in 1980 to advocate for legal change, accelerating the physician aid in dying movement.
We were not sure how much support we would get. We decided to hold an initial sort of organizational meeting. We had no money and no organization. We hung notices on trees and in supermarkets, and 200 people came to that meeting. That was the very first meeting of our Washington State chapter.
Interest in the Right to Die movement further skyrocketed in the early 1990s due to the actions of Michigan pathologist Jack Kevorkian. Appointed the ironic title Dr. Death, Kevorkian proceeded to assist patients in taking their own lives if the law could not provide for them. Jeanette Adkins, diagnosed with Alzheimer's disease in 1989 and unwilling to let it progress further, was the first of Kevorkian's 130 assisted deaths.
What I have to say about Dr. Kevorkian is, even though he pushed the envelope too far, he was the one that started the conversation in the United States in a public way. He really got out there and said things that people were saying privately but afraid to talk about it publicly.
The non-terminal classification of Alzheimer's sparked tremendous controversy, with many questioning the legality of assisted dying. Kevorkian allowed patients to administer themselves a lethal substance at the push of a button utilizing a suicide machine, a system that allowed him to avoid legal prosecution on the grounds of having no direct involvement. In April of 1993, the Hemlock Society developed into Compassion in Dying and End of Life Choices, a pair of organizations to counsel the terminally ill and provide information about end-of-life options. The organizations also sponsored suits challenging state laws against assisted dying and ensured fair treatment for the terminally ill. In response against growing support, the New York Task Force on Life and Law published a report titled When Death is Sought in May of 1994, deciding against the legalization of assisted suicide and euthanasia in New York State. The report detailed the benefits and drawbacks of legalizing assisted suicide and euthanasia, bringing to the surface the ethical and moral controversy associated with assisted dying. The West Coast pushed forward regardless. In November of 1994, Oregon Ballot Measure 16, more commonly known as Oregon's Death with Dignity Act, passed with a majority of 51 to 49%. The
We drafted the law in 1993 and we filed it, and it became a public document toward the end of that year. And in 1994, we waged the campaign to pass the law. And it was a very high-profile campaign. It drew national attention. And it was at that time thought to be somewhat controversial. And we knew that voters supported it by a majority, but the idea of actually changing the law to allow it was something new and quite different. And so it was a very controversial year, 1994, and we passed the law, and to much fanfare, we were immediately in federal court because our opponents sought an injunction.
The opposition proceeded with ambitious counterattacks, culminating in District Court Judge Thomas Hogan issuing a temporary restraining order and injunction against Measure 16, barring the state from putting the law into effect. Judge Hogan ruled in Lee v. Oregon that ballot Measure 16 deprived terminally ill patients of safeguards against suicide. Thus, the Death with Dignity Act was unconstitutional on grounds that it violated the Equal Protection Clause of the 14th Amendment of the Constitution. The ruling was immediately appealed by supporters of Measure 16 and revoked by Oregon legislature in 1997. Proponents of physician aid in dying requested the court title the new enactment neutrally, changing the name from assisted suicide to death with dignity. With the choice placed once again in the people's hands, voters statewide truly questioned their responsibility in ultimately deciding the fates of terminally ill Oregon patients. On November 4th, 1997, the people of Oregon voted 60 to 40% against ballot Measure 51, an attempt to repeal Measure 16. The Death with Dignity Act finally took effect on October 27, 1997, and gave patients an alternative to aggressive treatment in hospitals, allowing them to live and die on their own terms. 16 terminally ill Oregon residents made use of the law in 1998, ending their lives with physician-provided medication. In 2001, Attorney General John Ashcroft issued an interpretive rule stating that physician-assisted dying was not a legitimate medical purpose, and the provision of lethal medication violated the Controlled Substances Act, constituting the prosecution of physicians and pharmacists involved.
This time we went and got an injunction against the United States government, and specifically John Ashcroft and the Drug Enforcement Administration. And our goal was to stop the investigation and prosecution of Oregon physicians and pharmacists that were practicing under Oregon law under the Oregon Death with Dignity Act.
The court later ruled in favor of Oregon 6-3, but appropriately questioned the rights and responsibilities of physicians and pharmacists involved. To address the rights and legal risks associated with the Oregon Death with Dignity Act, writers implemented numerous safeguards and very specific eligibility requirements. Section 4 of the Oregon Death with Dignity Act also indicates that no healthcare provider shall be under any duty or legal requirement to participate in the provision to a patient of medication to end his or her life in a humane and dignified manner.
It is a perfectly legal procedure, but if people don't understand that or identify them as death doctors in some way, physicians should not have to endure or be subjected to that kind of an accusation. It should be a completely personal, private matter. Those who wish to do it should be enabled to do so. This is an opt-in law, not an opt-out law. So you choose if you wish to use it, and the choice is that of the physician, the medical providers, and the patient and their families. There is no pressure or obligation on anyone's part to do this.
The implementation of Oregon's Death with Dignity Act functioned as a catalyst, bringing discussions of assisted dying out of closed doors and providing terminally ill patients with not only the right to live of their own accord, but also the right to die as they wish. Ballot Measure 16 became the first law in American history to give patients the right to die through the use of prescribed lethal medication, and has received growing support ever since. Death with Dignity Acts have since passed in the states of Oregon, Washington, and Vermont, with legalization supported in New Mexico. In 2004, End of Life Choices merged with the Compassion in Dying organization to form Compassion in Choices. With 25 active chapters, it is the largest organization of its kind, ensuring access to end-of-life options for terminally ill patients. As the sole unifying factor connecting all of Earth's inhabitants, life is held most precious to all. Humans throughout history have fought to gain their independence, their right to live, and they also fight for the right to die.